Hello and welcome back to Coin Lady channel. And I don't know if I've ever seen a more satisfying smackdown of the SEC by a judge than this one. Of all the smackdowns in the SEC Ripple case, my favorite is when Judge Netburn said the SEC was being hypocrites and wasn't acting in faithful allegiance to the law. That'd be me, then? Simply because it was only one paragraph long. In terms of smacking down the SEC, that would be my favorite moment. However, the Voyager of the Voyager debacle provides the most detailed and comprehensive rebuke of the SEC that has ever been published. As many of you will remember from last year's crypto panic, the Voyager cryptocurrency exchange went out of business and eventually went bankrupt. This time last year, in the heat of summer, Voyager filed for bankruptcy. The SEC has filed numerous claims in an effort to halt Binance's US proposed $1 billion acquisition of Voyager. Furthermore, the judge was having none of it. Additionally, I'd like to tell you this. Okay, I'll give you two explanations. To begin with, it will be extremely satisfying for XRP holders to watch a judge smack the SEC around like the little pricks in the $1 that they are. I'm blown away by the sight. The experience was utterly delightful. Furthermore, this may aid the SEC's Ripple investigation. In the beginning of this video, attorney Jeremy Hogan makes a comment that I would like to share with you. But he believes Ripple shouldn't submit this outcome to Judge Torres so that she can make an informed decision. Regardless, there was a lot to dissect, and I heard feedback from not only attorney Hogan but also attorney John Deaton and attorney Bill Morgan, who are all embedded in the XRP community. In any case, I feel the need to clarify something before continuing. I come from no financial or legal background. Nothing I say or write should be taken as recommendations to buy or sell any particular security. I'm just a hobbyist who finds enjoyment in creating educational videos on crypto-related topics for YouTube. In any case, today's headline from CoinDesk: Binance Voyager US pausing rejected by the bankruptcy court. Binance's offer to acquire Voyager Digital for $1 billion is fair and should be approved. A bankruptcy judge issued a ruling in a court filing on Wednesday, rejecting a request from the United States government to pause the case pending an appeal. Attorney for the United States Damian Williams argued that the agreement should be changed or nullified because it effectively clears Voyager and its employees of any wrongdoing with respect to tax or securities law. Judge Michael Wiles of the Southern District of New York, however, argued that the deal he had previously approved does not harm Voyager customers who have not been able to access their crypto. In July, the company filed for bankruptcy protection, and if the SEC had its way, no one would have been surprised. Investors, who they're sworn to protect, would have been harmed. Also, I'm going to quote extensively from the judge's decision so you can see why I'm so ecstatic to share this with you. We in the XRP community think the judge's observation that the SEC hasn't established clear guidelines for the industry and that businesses are fumbling along in the dark is spot on. And even if you tried to implement Howie, what good would it do? Gary Gensler is all boldface and like, oh, everything's very clear as he addresses everything that we've known to be true and have been complaining about for over 2 years despite the SEC's denials. Well, the judge has a different opinion, so I've had to watch this for a while. This is just one of the many reasons why I have high hopes that the SEC will rule in favor of Ripple and XRP investors will benefit. This is a tweet from lawyer Jeremy Hogan. He predicted that Ripple would use the bankruptcy judge's ruling in Voyager's case as evidence for its own fair notice defense. He posted a screenshot of the ruling, praising the judge for articulating the difficulty of crypto projects. Thus, the judge in that case has written this. To which I reply, I also know that Voyager operated in Binance, he says. Currently, the regulatory climate in which the U.S. operates can be described as chaotic. Put a halt to that right this minute. I have to apologize to Gary Gensler. What exactly did you mean to say that was crystal clear? Since no one believes it, it is irrelevant. A portion of the general public who aren't paying attention could be fooled. Kim Jong Gensler, you aren't fooling the people who matter because they aren't interested in crypto when you're talking on CNBC or whatever. For whatever reason, Judge continues, there are businesses that have been operating as cryptocurrency brokers or exchanges for years without being subject to clear and well-defined regulatory requirements. This is fantastic. When it comes to determining whether cryptocurrencies fall under the purview of the Commodity Futures Trading Commission (CFTC) or the Securities and Exchange Commission (SEC), or neither, regulators themselves seem to be at a loss. In fact, there is no consensus on the criteria that should be used to make the call. Despite the fact that cryptocurrency exchanges have existed for a while, this confusion has persisted. In fact, the judge claims that it is unclear whether cryptocurrencies are commodities, securities, or something else entirely. However, Kim Gensler insists that the identity of the dupe is crystal clear. Nobody, no sane person would do that. Listen to me, people. Look at this now. Here, attorney Bill Morgan provided a superb breakdown, complete with quotes from the judge. And this is a dead-on depiction of the thoughts going through the judge's head at the time. That's why this is such a fun rematch, because of that last point. When it reaches the palate, there's just a sudden "oh, that tastes so good" feeling. It's fantastic. Here is what Morgan, the lawyer, had to say about it. Parts of Judge Wiles's decision in the Voyager matter read like a summary of a fair notice defense from the token's perspective. I'll pause to note that the token is the cryptocurrency of the Voyager exchange, much like Binance has its own Binance coin. Voyager currency, or VG, is a digital currency. So, let's hear more from attorney Morgan. The SEC's lawyer argued that the staff's view that the VG token exhibited characteristics of a security was persuasive, but that the commission had not yet taken a position. People, here's something to consider. Even though the SEC didn't take a position on the VGX token being a security, they tried to convince the judge to block the deal anyway because some of the staff members held that view. Have we heard this somewhere before? The government takes no stance. Bitcoin has no official status at all. That should have been enough to convince the judge to put a stop to it. And now, the judge's opinion. Because, as he explained in his initial letter, the SEC staff thinks the VGX token is a security even though the SEC as a whole hasn't decided yet. Second, I was told by SEC employees that they consider Binance US to be a securities exchange even though it is not officially registered as one. Nonetheless, the Commission has not taken a stance on the issue. Here, they make the same assertions about the VGX token and the exchange itself. But, once again, in an effort to thwart this deal, which would benefit investors by allowing them to recoup some of their losses, SEC is attempting to halt proceedings, but the judge is having none of it. You spoiled brats, you. He didn't actually say that, but I wish he had because it was fantastic. Little snot-nosed brats, I'm speaking for myself now. Absolutely not. Neither of these are conclusions that you arrived at on your own. Then, how are things supposed to develop? Indeed, that didn't happen. According to the judge, even though the SEC provided these explanations of what the SEC staff apparently believes, the SEC made it clear that only the Commission itself could take a formal position on behalf of the SEC and that the views of the staff did not constitute the official. And that's where it ends. But obviously didn't represent the SEC's official stance, as far as anyone could tell. The meaning is clear from the surrounding text. Judge Wiles, it's nice to have you here in the crypto space, attorney Morgan says. When it suits the SEC, staff members speak on behalf of the Commission, but otherwise their statements reflect the personal opinions of staff members or the divisions within the SEC, not the Commission's official position. The FCC was able to get permission to discuss the staff's religious views. Really, that was a big move on their part. Simply put, he's making light of the situation. This was very bold on their part, as the FCC is well known for fighting disclosure of sensitive documents like those related to the Hinman case for an entire year by asserting multiple claims of privilege. The judge's remarks were then relayed by him. Even though the SEC has been given permission to disclose the staff's beliefs, the SEC has stated that it is not authorized to and has no intention of presenting any evidence on these issues or even further explanation as to the basis of what beliefs the SEC staff may have. The end result is thus put forth the opinion of a few employees rather than the SEC's official stance, which is that the SEC has no stance on the matter. And then they let that claim hang without providing any evidence to back up the claims of those particular SEC employees. The judge was not amused. The music to my ears, the music to my ears. Feeling like, okay, now, which judge is going to say, I can't wait to see is encouraging, right? Then, Attorney Morgan makes the following statement. But the SEC did not provide any evidence as to why or what about VGX constitutes a security. Gensler claims to have an intuitive understanding that all alternative cryptocurrencies are securities, but he has provided no evidence to back up either his claim or the Commission's. The judge had serious reservations about the debtor's ability to identify the security characteristics of the VGX token. It's possible he doesn't believe in the Gensler lots of clarity argument. Then he sent over this snapshot of the screen. The judge also wrote the following, which reads as follows: I disagree with the SEC's position that these problems preclude confirming the debtor's plan. First, I disagree with the argument that the court and the debtors are responsible for determining whether or not the VGX token constitutes a security and whether or not specific activities by Binance give rise to registration concerns. This is fantastic. As you can see, there is a distinct absence of rules and regulations. And now the judge is publicly stating what we in the XRP community have known for over 2 years. It is unclear what exactly constitutes a securities violation in regards to cryptocurrencies. Again, how are they supposed to draw such conclusions in the absence of adequate criteria? He's putting everything we've been saying to the test by taking them along. Because of this, I feel so damn fulfilled. And then, Attorney Morgan says, the judge just didn't understand how many of the parties could address the SEC's concerns with the limited guidance the SEC had provided. He felt a little irritated. He seems to have been left to speculate on the SEC's justifications for classifying as a security. Plus, the judge has some additional comments. With the limited guidance that the SEC has provided, he writes, I do not know how many parties could possibly be expected to address the SEC's comments. The SEC did not provide any justification for classifying VGX tokens as securities, so I can only speculate as to their reasoning. Similarly, the SEC gave no justification for its suspicion that Binance US was acting as a securities broker. I have no idea, for instance, if there is a single cryptocurrency token that Binance may have traded to us that the SEC thinks was a security and for which the relevant remedy may simply be to cease trading in that token, or if the SEC has different theories. For us to even begin to address the problems, we have to speculate as to what those problems might be, and there's no guarantee that we'd be addressing the right things. To the point, too. In that respect, he is completely correct. What the judge is supposed to do is speculate on what the SEC's arguments could have been and then rule in favor of the SEC, despite the fact that common sense says no. Definitely not. Sadly, that did not occur. And then Attorney Morgan wraps up his thread by stating, the crypto world has been left to guess for years. The SEC brought the crypto market's uncertainty and confusion into Judge Wiles' courtroom. If a judge doesn't like something, they tend to ignore it and move on. You're going to adore this. What an absolute joke, tweeted lawyer John Deaton in response to the thread he had retweeted. Some of us believe the token possesses characteristics of a security, but the SEC has not made a ruling either way, which has become their main argument. We think the people we swore to defend should be made whole, and we want you to stop that from happening. That's exactly what the attorney requires, and it's also exactly what the attorney should obtain as a result of the business transaction. It worked out to be 73 cents. They obviously won't get everything, but considering the complete disaster that the pandemic last year was, things could have turned out much worse. Binance are stepping in to help them out. That way, those who still had funds on Voyager when it crashed can get the vast majority of their money back. I'll tell you what, if I were one of the people who had funds on that exchange, and I'd been through this for almost a year, honestly, just months away from a year, I'd be pretty damn thrilled after thinking that I may not be getting a damn dime. The SEC was opposed to compensating these investors. Why is that, exactly? For the time being, they intend to maintain their aggressive expansion of government authority. So that's what it is. For the simple reason that this hampers their attempts to expand their sphere of authority. It goes against their stated purpose to screw the investors. Our ostensible goal was completely disregarded. It's serving their intended purpose. Just as I predicted in the live stream of Crypto Law, Attorney Deaton has confirmed that the SEC is indeed losing in court. Despite what the SEC may think, the law is not on its side. When the SEC's overreach is combined with its contradictory statements and actions, judges have no choice but to call it out. Exactly. They have gone over the edge of their skis. The SEC has gotten away with quite a bit, and for quite some time. However, things seem to be getting more and more extreme. They have no idea how far out of whack they are if they do. Simply, it finds a new purpose. In any case, I'm sure they are just talking to themselves in their own little bubble. Since this is the norm, it's just another day being an asshat at the SEC, right? But every day, they go further and further out of their minds. As a result, the courts are rejecting these outlandish claims and novel theories as they are brought to trial. And so, we shall observe what transpires. And this one is a good time. I was grinning and laughing as I read this and planned out this video's content, so I can only assume that you had a similar experience. The whole thing was just making me laugh. Oh, I knew the community would appreciate this one, so I sincerely hope you did. My sincere wish is that you did. But I really enjoyed reading this. It's a relief to know that, despite the SEC's usual nonsense and lies, justice can be served, and I'm grateful for that. I believe it will come to pass for XRP investors soon enough. I'm not a financial expert, so please don't ask me about the SEC versus Ripple case. Nothing I say or write should be used as a basis for making any kind of investment. In the end, please like and subscribe my channel. See you later, bye.